Good afternoon and welcome to another session of Lunch and Learn. Today we will be discussing how to calculate each parent's contribution when it comes to maintenance. So in the previous webinar, we've discussed how to work out the child's expenses. And today we will be spending some time on the calculation on how parents, the portion of the parents would be allocated or apportioned to the maintenance. So if we look at the just the webinar overview for today, what we will be discussing. Today we will be discussing, if I could just make it a little bit bigger, yes. Today we will just have a short recap on what was said regarding the children's expenses in the previous webinar. We will be discussing some of the legal provisions of the legislation of the Maintenance Act, specifically Section 15.3. We will also delve into what is meant by the respective means by each parent, and with reference to some case law that deals with those portions. We will also look at the South African Law Reform Commission's recommendations regarding what is meant by the means of a party, and we will go into very much detail on how to use the joint income formula when it comes to calculation of the parents' contribution towards maintenance. Two issues that we will be discussing is what will happen if the assets are being, or the income is not being declared by the other party. How do we deal with that? As well as, say for instance, if the father is a taxi driver or he works for himself, how do we deal with those type of matters? And with regards to the payment of maintenance, or specifically the parents' portion. So just as a recap for those that have just joined us, very much welcome to all of those joining us from Facebook. We're streaming to two Facebook groups. We are streaming to two YouTube channels, as well as the Lunch and Learn website. I see that we've got quite a number of attendees. Very, very welcome to each and every one of you. If you have registered, you would have received a email link together with in the email, and on that there is obviously, like I said, there's the link for this webinar, but most importantly there would also be some pre-reading material that you could read through, peruse. That's just some background information regarding the session today, and most importantly obviously the handout and resource section where you would find downloads of, or made available as downloads, all the cases that we refer to, the handout together with the slides that we are using for your download and usage. So before we get to that, maybe we should just get to what we've done in the previous session. In the previous session, we have dealt extensively with how to complete the J101 form. That was now how to complete the application that you need to submit. And we focused mostly on specific issues, obviously on how to complete that. And in your handout of the previous webinar, you would have found this document where it actually tells you exactly how to fill in the J101 form step by step, together with the comments. And we've discussed in quite some detail the differences between direct costs and shared costs, and that needs to be filled in on the application form, specifically under the total column. And we explained how you can distinguish between the self and the children's portion when it comes to maintenance. And just as in amplification thereof, we mentioned that you use the principles of good versus a good as a baseline, where we allocate 1/3 towards the minor child and 2/3 towards the adult. But that is just as a baseline used in the principles that we found in case law in the good versus a good case, and there was also reference made to that in the Santam versus Fourie case. Now, we've dealt with that, and we also mentioned that those principles are not fixed. That is not cast in stone, and that needs to be adapted, because we are using a discretionary system in the South African law on how to work out the child's expenses. So what we've done in the previous session then was to discuss how to work out and to complete this whole section that deals with the parent and the children, and when it comes to maintenance, in order to calculate what is the amount needed for for maintenance. And if we can just scroll down to the end of the portion, or the end of the form, just after section number 21, there you would have the total expenditure of what is needed for child maintenance. So now what we've done is we have the total amount that is needed for the children in order to survive on a monthly basis. We've established that is the amount. And now in today's webinar, we will be discussing on how to split that, how to split that between the mother and the father according to their means. And that is by no means an easy task. There is, although the Act is very clear regarding that, but the implementation thereof in the courts are sometimes not very clear and crystal clear. So you would find that some courts distinguish and they use a different method than another court, especially we see that in different provinces. The Gauteng province uses a slightly different formula, slightly different angle when it comes to calculations of these type of matters when it comes to the expenditure of the children, as well as the division and the apportionment of the parents' contribution. So if we delve right into it and we get to the first portion is the discussion of the legal provisions of the Maintenance Act. Remember, we said that the Maintenance Act is the act that we use in order to guide us, to tell us how do we need to split the apportionment. And if you look at section 15.3, what it clearly says in section, and I'm referring to section 15.3A2, where it says that the courts would take into consideration that the parents' respective means or shares, they share the obligation, and it should be apportioned between them according to their respective means. Now, the Act is not clear about what is meant, or a definition about what is the means of the parties, and we'll be discussing that in the next slide. Referring to section 3B, it says that, the duty of the parents to support the children is basically any amount so determined that shall be such an amount as the maintenance court might consider fair and reasonable in the circumstances of the case. Now, here is reference to the discretionary system that we use in South Africa as well when it comes to child maintenance. So what is meant by means, the respective means of the parties? Now, in the layman's terms, in the simplest terms, it would equate to what is a person's income, what is their net worth, what are they worth, in order to establish what is their means. So what is the possibility for them to pay maintenance? In simple terms, what is their income? So first of all, what we look at is we look at the income, the salary, or the weekly wage. That also might be inclusive of a SASSA grant or children's grant. So that would all be income derived from a certain source. It might come from the employer, it might come from the government, it might come from pension. Those are all considered to be means in the form of income. Furthermore, there's also very much case law which says that the courts would also look at investments or savings or even life policies when it comes to what is considered means. And that the court could actually make an order that you have to realize some of your capital of your life policies and or investments in order to fulfill your maintenance obligation. And that would also fall under what is considered the respective means of the parties. We also make reference to cryptocurrency. Nowadays, we see that quite a lot, that people are having cryptocurrency, virtual currencies, that is also added to their financial portfolio. And those are also considered to be part of their means or their income. Furthermore, if we look further, the value of shares in a company is also considered to be part of their respective means. So the value, if he is a director of a company and he gets dividends, surely that also forms part of his financial asset base, and that would also fall under what is considered means. Rental income, yes, that is also very important. If you have a fixed property that you own, or you rent perhaps, or you rent certain portions thereof out, the rental income, if you have a house and you have a little hooky outside little Wendy house that you rent out, and you have, or the other party gets rental income from that, then that is also considered means. That is also considered to be part of his income. If you rent it out through Airbnb, Booking.com, or some of those sites, that would also, the income derived from that would also be considered to be part of your means. Now, the Law Reform Commission, and we'll get to that in a moment, also then mentioned that, even cattle or livestock or anything tangible could be used as a form of means. And they referred specifically to livestock and to cattle. So if the father is coming from the Eastern Cape and he has a certain amount of cattle, yes, that also forms part of his asset base. That would also be considered to form part of his means. So the reason for that is that he could sell some of those cows or the cattle or the livestock that he has in order to realize and to capitalize on that, to make that money and to pay maintenance. Obviously, proceedings from a trust or services, all those could also be considered ways of or forms of means. If you have any proceeds and you're a beneficiary from a trust, that is not excluded. That would also form part of your means. So if one looks at the case law that deals with that, and there's quite a number of case law that deals with exactly what is the parent's portion. Although the Act is very clear that it needs to be apportioned in terms of Section 15, we've got two cases there that I'm just going to refer to. The one is Verivatu versus Verivatu, which is a 1980 case where it clearly said that the parents are obliged to provide their children with everything they reasonably require for their proper living and upbringing according to the means of the parties and their standard of living. In addition to food, clothing, educational requirements, accommodation, the provision of amenities such as electricity, water, linen, cutlery, and laundry should also be taken into account. So if one analyzes and unpacks the Verivatu case, which is quite an interesting case, and that is also found in the resource section that you can download, it says that it is what the child needs that is reasonably required for their proper living and upbringing according to the means of the parties and their standards of living. So that poses an interesting question, because what happens if the father or the children are accustomed to a certain way of living, a certain way of upbringing? Then surely that needs to be adapted. If I use the example, a child in an informal township of 8 years old and one living in Bishop's Court, let's use Bishop's Court and Bishop Lavis, for example. The child in Bishop's Court would have different needs in terms of the standard of living than a child that would have in the Bishop Lavis. That's just an example, not to be derogatory in any way. But you get the idea of the distinguishment between the standard of living and what their actual needs are. So yes, in that sense, we also refer those to luxuries. Would that be included? Obviously, yes. If the child is accustomed to that, then surely the luxuries would be considered necessities, such as, for example, Wi-Fi. If they're in private school and they do homeschooling and they need to do tasks and stuff like that, then sure, most definitely Wi-Fi would be considered not a luxury, but absolutely a necessity. A different case, or another case that we can refer to, is the Lamb versus Sack case. I can just make that one a little bit big. The Lamb versus Sack case, where it says that both biological parents must support proportionately according to their means, regardless of whether the child is extramarital. So, with other words, if it's a legitimate child or a legitimate child born in or out of wedlock, both biological parents must support them proportionately according to their means. Now, these are just two cases that I've highlighted. There are many more. There are much more cases, and those are all in the webinar handout, and the detailed cases will also be put under the resource section. So what are the recommendations that the South African Law Reform Commission considered? And that was done during panel discussions last year as a pre-entry introduction to the proposed amendments to the Maintenance Act, which we will probably see more interaction with public and the judiciary and the parliamentary committees when it comes to discussing all these matters of being it open for public discussion. So one of those things in Chapter 4 was the recognition of other forms of payment of maintenance awards. Now, for the life of me, I don't understand why they call it a maintenance award, because it's not a prize. It's something that the parents need to pay. It's part of their common law duty of support. But they call it maintenance awards. That's basically what is meant by that. It's just the amount of maintenance that needs to be paid. And the South African Law Reform Commission, said that they want to add the following definition of maintenance order, where it says that any payment in kind, either by way of supplying specific goods or livestock or providing a service, or payments of the sum of money, including periodical payments thereof. That's monthly payments. So they said that a maintenance order would actually mean, they gave a definition, they said that a maintenance order would be payment in kind, payment by any other way of, it could be supplying of specified goods, or it might be livestock, or it actually might be providing a service, or the normal one like we know is the payment of a monthly amount of maintenance. So that is the suggestion of the Law Reform Commission, to include what is specifically meant by maintenance order. So one could see here that they are moving towards being innovative, like they said in the Ballantyne versus Ballantyne case, using innovative ways of making this whole maintenance system work. They are using, or they are suggesting, that payment in kind could be used. So that would be, for example, payment of goods, it's supplying of specific goods. So, for instance, the father has a chicken farm, or he can supply 2 chickens per week instead of paying the normal price of maintenance, or even delivering a service. He might say, right, you know what, I would go and I would pick up the kids and I would collect them from school, I would take them back home. So I would contribute in that way towards maintenance. So those forms are also recognized. But that would also amount that there would be a problem, because how do you calculate that? How do you put a monetary value on the service, the time that the respondent, let's call it in this case the father, is how do you monetize that, to say, but you know what, he spends time picking up the children, and it's his petrol and it's his car and the wear and tear on the car. So how does that equate to a sum amount of maintenance which might be reasonable? So the Law Reform Commission suggested that the section 16 be inserted to say that any court making an order for payment in kind, as defined in the definitions, must make an order in the alternative for payment of the sum of money equivalent to the estimated value of the order for payment in kind. So that is quite a mouthful. So what that basically means is, like I've said, if the father supplies 2 chickens per week, the court would then say, all right, you know what, you can supply 2 chickens a week, and the cost of 2 chickens would be, for example, 100 Rand. So the court would then be obliged, in terms of the proposed section 16, to make an order to say, father, you need to give 2 chickens per week, or the amount of 100 Rand towards maintenance for the children. That is basically what is meant by the inclusion of section 16. Right, so now we come to the joint income formula. We've discussed that now we have got the amount of maintenance that needs to be paid. So that amount now that is reasonably necessary, and which is considered to be fair, needs to be split between the 2 parents. In terms of section 15 of the statutory provisions of section 15, it says that it needs to be apportioned between the mother and the father. So how do we do that? Like I said previously, everybody loves a recipe. They want to work through a system where it says, you know what, this is what we should do. And that's exactly how we are tackling this problem. If we can just go to that slide. Yes, there it is. So section 15 of the Maintenance Act, then, like I just said, was that the obligation should be apportioned between them according to their respective means. So here is the recipe, and we'll be discussing this recipe in some detail in a couple of minutes. So what we do is we add both parents' contributions, or the income earned by them, their joint income, we add them together. So we take the payslip of the father, we take the payslip of the mother, and we join those together. We get a total amount of the income between both mother and father, both the biological parents. Now that might also include shares, it might also include dividends that he's entitled to, that might include a 13th check, it might be included in the rental income. So anything that is considered means needs to be calculated on there. What we do next in step 2 is to take the applicant's salary, that's usually the complainant, the mom, and divide it by the joint income to get a percentage that each parent needs to contribute. So we take the salary, and I'll explain that in a moment with some graphics so that we all understand that. And next, what we would do is we would apportion the percentage of each parent towards the total amount of maintenance. So these are just big words, and it sounds quite heavy, but in effect, it is not that difficult. And if we go to the next slide, then we can actually explain that in layman's terms so that you would understand that, and it would be more visual for you to understand. So what we do is in step 1, let's just start with step 1. We go from the premise that the father earns an amount of 50,000 Rand and mom earns amount of 15,000 Rand. So dad pays 50,000 Rand and mom pays 15,000 Rand. So the total amount of income between those two are 65,000 Rand. We add those two together. That is in step 1. That's the first thing that you need to do. So we need both parents' income, and we add those two together. So next we need to work out the percentages. And that's a simple calculation, a simple mathematical calculation that could easily be done. So in terms of the joint income method, you then take the two salaries together, which we've done in step 1, and then you take the applicant's salary, her individual salary, and divide it by the joint income of both parties and multiply that by 100%. And then you would get a percentage of what is her considered contribution towards maintenance or the child's expenses. That would be a correct apportionment of the joint income. So if we look then, you take the 15,000 Rand, that is the mother's salary, and you divide it by the total amount, the joint income, you times that with 100%, and you get to an amount of 23%. The same goes for the father. Now we need to work out what is the father's apportionment, the father's contribution. And you would simply then take the father's salary and divide that by the joint income times 100%, and you would come to a percentage of 77%. Obviously, in terms of mathematical terms, if you add the 23% and the 77% of the father, the total amount would be the 100%. And then you would know that your calculation is correct. Now, this is usually done in front of the maintenance officer, usually, or if the parties agree to it beforehand. But these calculations are usually done in front of the maintenance officer, or if it goes to court in terms of Section 10, then the magistrate would do these certain kind of calculations. So when we calculate then in step 3, we calculate the needs. We've discovered and worked out that 77% goes to the father, or he's liable for 77% of the expenses, and the mother is liable for 23% of the expenses. So now, if we go back right to the beginning, we've established the certain amount that the child needs. That's what we've done in the previous session as well. So we've established this is the amount of maintenance needed for the children or the child. For example, let's say that amount is 10,000 Rand that the child needs. Now, to apportion that, you simply make a calculation to see 23%. Now, that's the mother share. 23% of that needs to be paid by the mother, and then the gross, the balance thereof, the 77%, needs to be paid by the father. That's simple mathematical terms. Of course, one needs to take into account all the other income of the parties in order to make it fair for the pay, the working out or the calculation of the maintenance amount. So the next question would be that pops up quite often is, what happens if the father is a taxi driver or he works for himself and he does not declare his income? So my suggestion would be, and we see that in quite often, is that, you know what, we depend on the mother to do some homework beforehand. So, you know, the courts do not have the capacity, they do not have the personnel, they do not have the infrastructure to investigate each and every matter to the absolute extent that it needs. Unfortunately, it is so. We have some constraints with the amount of maintenance investigators that are available, because there is the ideal would be that there is a maintenance investigator for every court, but in practice it does not seem like that. It seems like there is one, maybe two courts sharing a maintenance investigator. In some rural areas, they never see a maintenance investigator in any event. So we would rely then on the mother to do some homework. Mom, pop onto Facebook. If the father is a taxi driver, then pop onto Facebook and see, you know, what does he post? Does he post, yeah, you know what, he's got a new car, or he bought something new, or just get a general feel of what is his financial situation at that stage. Do your homework beforehand. Look on social media, like I said, Facebook. Take photos of the taxi. If you see him drive around with a taxi, take some photos of the taxi. Very important. You want to establish, is the taxi his? Does he own the taxi, or is he driving for somebody else? And the maintenance investigator might be able to assist you in order to use or to track the owner of the taxi by using the e-Natus system. Now, that process takes a little time in court, but it is available. They could do that. So take photos of the taxi to say, but you know what, because the father might come to court and say, but you know what, he does not earn a big income. Just now and then he drives a taxi. If you have proof of a photo and say, right, you know what, I've taken this on the Monday, the Tuesday, the Wednesday. So there is a certain pattern forming. He is driving a taxi each and every day, and that you can present to court as evidence as well. It might also be a good idea if you know that the route that he drives, and that's quite easy, because usually at the back of the taxi there's the route that they drive, and you can make quite a simple estimation to say, but you know what, he drives that route probably 5 or 6 or 10 times a day, and then you can find out speak to some of the people, how many times do they stop, how many people do they pick up, and that would basically come or boil down to a assessment of what amount is he getting from that. Obviously, if he works for somebody else, he works on a commission base. Now, in most instances, the taxi owner will not divulge that information. They would just simply lie, because we work with a cash base or cash basis. So the taxi owner obviously will not declare the full amount that he gets and that he needs to share with a taxi driver. So we do have difficulties in court with proving this. Well, but like I said, get all your homework ready, give that to the maintenance investigator, let them investigate that. But do your homework, get the routes. How long does he drive? Does he drive from 8 o'clock till 10 o'clock at night? Because that might also have an influence on the time that he could actually have to earn an income. So that is just, in short, what you could do in these instances. But like I said, it does pose quite a severe constraint on exactly working out what are the means, what is his income from driving a taxi. So next would be that we could discuss is, what do we do in an event where the father hides assets or is not declaring his assets or his bank accounts? So what you could do there, Section 7 says that the maintenance officer could instruct the maintenance investigator, like I just said, to gather info like a credit report. They could get the details of the vehicle using the e-Natus system. They've got access to Windeed, which means that they could get the details of immovable property or fixed property that he owns. Those are all things that could paint a picture of what is his financial basis, what is his asset base when it comes to the apportionment of maintenance. The maintenance investigator also has the means or the ways and the facilities to subpoena all the banks to get the information to establish how many bank accounts does that father have. Because in most instances, they have 2 or 3 accounts. They've got a Capitec account, they've got a Standard Bank account, and they only divulge one account with the least amount of money. But it is available in terms of Section 7. Furthermore, if one goes further, Section 8 says that the maintenance officer could actually request the court to subpoena people, not only the banks and the financial institutions, but also subpoena people to give information. And that could happen prior or during a maintenance inquiry. So this could be very valuable if you know that that the respondent or the father is hiding assets. He's got certain deductions from his payslip, and you know what, he is literally hiding money in plain sight. Then you can actually ask the court in terms of Section 8 that the court or the maintenance officer requests the court for a subpoena of the HR manager to give evidence regarding the financial position of the respondent. In terms of Section 9, the maintenance officer could also request the court for a subpoena of people to give evidence or to produce a book, statement, or a document. So I've used that quite a number of times. We asked for a subpoena for specific people, and that's usually when people they have a big asset base and they hide assets in trusts, and they hide trusts in items in financial instruments such as life policies or retirement annuities, and they do that maliciously. What I would do then is I would request in terms of Section 9, I would request the maintenance officer to request the court to subpoena his auditors to come and testify in court. And then you scrutinize, then you absolutely brunt them, and you just go absolutely nuts with cross-examination, because then they have to produce all the evidence and they have to produce the books, statements, or any accounts pertaining to that in order to establish his financial base. So that is available as well. It's not very oftenly used because it is quite time constraining, and most of the maintenance officers do not know how to utilize this section to the fullest. So where are we in the process? We have discussed now how to complete the J101 form. That's the maintenance application form. We've discussed how to work out the child's portion. And now in this webinar, we've discussed on how to apportion the parent's contribution towards maintenance. So we are moving towards coming to court, submitting your application form, and what will happen then. Like we said in previous webinars, we are running through the whole process. We're chunking it down. We're breaking the whole process down. So now we've basically completed the complaint phase. We've completed all the paperwork phase. Now we are moving towards how to get everything ready to submit that application to court in order for you to bring your matter to court, for the respondent to appear in court in terms of Regulation 3 directive that it needs to be in court for a Section 6 inquiry, which is done informally through the maintenance officer. So in the next webinar, we will be discussing how to get all your documents ready, how to compile the documents, where you must go, what you must do, and then we'll be discussing also a portion on how is a Section 6 completed? How is not completed? How is it done? What are the internal workings? What do I have to look out for? What type of questions can I expect? We will be delving into that before we get to the nitty-gritty on exactly how a Section 6 inquiry is done. So next on is our discussion. If we can just get Advocate Reuters on the line, then he can join us on there. Joining our discussion panel today is Advocate Reuters. He's a senior maintenance prosecutor at the National Prosecuting Authority. And today we talked about how to calculate the parents' contribution when it comes to maintenance. So my first question would be is, so many of these fathers do not declare because I understand that it needs to be worked out proportionally according to their income or their means. But the fathers very often hide their assets. Is there anything that the maintenance court can do to assist mothers where in the event where the fathers actually hide some of the assets or the money, banking accounts, stuff like that? Is there any assistance that the courts can give?
Yes, to start off with, when the maintenance inquiry is being conducted, the maintenance officer will warn the respondent that he needs to make a full disclosure of his financial interest, which in a case where he doesn't make a full disclosure in terms of Section 34, we can prosecute him for providing false information. Else, the applicant, while she's in the maintenance inquiry, should talk and say that, no, but I know of the retirement annuity that he had, or any other type of investments that he might have had while they were in a relationship. She shouldn't keep quiet. She should try and participate in that process and say what type of means the person has. Another way that is being used more in Gauteng, in the divorce courts in Gauteng, is a financial disclosures form that is being used. And that's another way that maintenance courts can somehow encourage a full disclosure by the respondent by making these financial disclosures forms available. I know that in most courts in South Africa, they don't use the form because it's not a J form, but that is a way that I find that maintenance courts can encourage the respondent to make a full financial disclosure.
So what is a J form? The listeners, we know what a J form is, but most of the listeners out there would not know what is a J form. And how does that differ from a financial disclosure agreement or form?
Yes, a J form is all the justice forms, like a maintenance application form is a J101. A maintenance consent form is a J214. So all forms that is used in the maintenance court, that is a form that have been developed specifically for the maintenance court, and since it's made by the Department of Justice, will have a J number. A financial disclosures form do not have a J number because it was an innovation by the Gauteng Maintenance Courts in order to somehow encourage the respondents to make a full financial disclosures. That's why it is not used uniformly by courts all over South Africa. But it's one document that I feel should have a J number in order to make the investigative process more easily for maintenance courts.
And the financial disclosure form is also done under oath. So there would be repercussions if you submit false information on that form because you actually declared it under oath.
Wonderful. Yes, the first page of the financial disclosures form have a warning, as well as the final page where you commission, obviously will have to be commissioned in front of a commissioner to make sure that whatever said in that document is a full disclosure, and the truth and the content is being verified by the person that makes that disclosure.
Another question that also needs answering is that if the mother knows that the father has a bank account at a certain bank, is there a way that the maintenance officer can enforce that bank to give that details or to inquire there? And what would be the process?
Yes, in terms of Section 8 of the Maintenance Act, the maintenance investigator will be able to summon the specific bank statements from the specific bank. And even if she doesn't know which bank it is, maintenance investigators have the inherent authority in terms of Section 7 to do a financial disclosure of all the 5 major banks in South Africa in order to then find out at which bank he have a bank account. So in a case where she's not sure, it doesn't matter, we can still summon all the major banks and find out where he's got a bank account if we have got his ID number.
Just another question. Many of the South African workers work either for themselves in a spaza shop, or they are a taxi driver, or they work in construction, and they do not get pay slips, or they get paid in cash. How is that dealt with? How can one establish what is that respondent's, that father's means to contribute towards maintenance?
The Law Commission also have a further definition of what means are. So means is not going to be limited to employability, that you're employed and you earn a salary or whatever the case might be. But means are also now going to be further defined to also include stock or any other type of thing, or any other type of means that you can provide. Like in the case of a taxi driver, the taxi driver will be able to take the child to school, or will be able to take the child to a clinic in a case where he needs medical attention, or can, in a case where it is a person working for himself, can take fruit and vegetables or livestock to the mother in order to then, in lieu of a maintenance amount of money, will be able to produce livestock or any other means that they might have.
So if the father comes and he says, "Oh, you know what? I can't pay maintenance, but I can give you 2 chickens per week, or a half a cow every second month, or some crops or vegetables, or whatever." How do you think the courts would? And we've discussed this previously. How do you think the courts would deal with that in order to establish? You know what? We're working with a parent's contribution towards maintenance, but how would that realize or materialize in a maintenance court? Because the father can say, "I'm going to buy 2 chickens and I'll give him a bag of bananas every week," or whatever. How would that be dealt with, that you can foresee that it would happen in future in the courts?
Yeah, as the Law Commission recommend is that obviously there will be now all of these other things, that livestock or whatever. What I recommend, or what I think is the way to deal with it, and this is uncharted waters, we'll see as we progress with the development of the law and applying the principles that the Law Commission is recommending, is by equating that bag of bananas to what you will pay for a bag of bananas in the shops, or 2 live chickens or 2 chickens that have been slaughtered. What is the equal value in case you buy it from a shop or wherever you buy your groceries from? So it will be advisable to make it equitable to whatever else you will be able to purchase at a shop, or whatever the case might be, equivalent of value, in order to determine how
In
much.
money terms.
Yes, how much.
Money terms. To say that, you know what, 2 chickens is $40. So he contributes $40 a week towards maintenance. So it will all be reverted back to a monetary value in order
Yes,
to establish the basis. Okay. You spoke previously about the means of the respondent. So that obviously means, as was done by the South African Law Reform Commission, they extended the whole definition of means to include other stuff as well, financial instruments, shares, all that type of stuff, director shares in companies, all that could be included. I just want to circle around the issue of cryptocurrency, because that seems to be popping up quite often.
Yeah. Well, obviously, means can include any of the that you already mentioned, including cryptocurrency. The only negative part of it is if the respondent don't make a full disclosure, how we will be able to track and trace it will be a little bit difficult, especially if it is cryptocurrency from international sources. There's no way we can summon, or in terms of Section 8, to get those cryptocurrency value of it. But the monetary value of it will be able to be determined based on the cryptocurrency value of other type of cryptocurrency stock at a specific time. But it will be able to be equated to a monetary value. The only problem is to ensure the verification whether it's true. It might be a little bit difficult for the investigative arm of the maintenance court.
Thank you for that. And that brings us to the end of our discussion session for today. Valuable information by Advocate Reuters, and he will be joining us on most of the Lunch and Learn webinars for some insight and for some discussion. If you would like to take part on any of the discussions, please drop us an email. Let me just pop up the email address and the details. Pop us in an email at info@lunchandlearn.org.za. If you want to be part of the discussion panel, or if you have some comments, if you have some advice for us, or if you would like to have a certain topic that needs to be discussed. We are very fluid and we're very flexible with regards to the Lunch and Learn webinars. We have a structure, or a program that we are utilizing for the rest of the year. There's probably about 47 more to come, so you can be looking forward to many more of these. But if there are some issues or some topics that you need to be discussed or need us to address, please drop us an email on info@lunchandlearn.org.za. And we can look at that, and we can most definitely squeeze that in, because there would be a need for that. Thank you so much again for Advocate Reuters for joining us. My name is Eugene Opperman. I'm a family law practitioner. I've been practicing family law for the past 23 years, specializing mostly in maintenance matters, domestic violence matters, and matters pertaining to children. Thank you so much to all the registrants for joining us today. For all the people watching online, I see there's loads of people watching online. There's many people on our Facebook pages as well. Thank you for that. Thank you for your contributions. Thanks for all the questions on the chat box as well on the YouTube channel. Like I said, if there's anything else that you need us to discuss or just want to get in touch with us, just drop us an email on info@lunchandlearn.org.za. Thank you so much. We see you next week. Next week we will be discussing how to prepare for a Section 6 inquiry. So we're moving towards going to court now. So how do we prepare for a Section 6 inquiry? So we will be discussing then just before that as well. How do you submit all the documents? How do you get all that ready? In what order should it be? What should you include? What should you take to court? So we'll be addressing all those issues specifically regarding to the Section 6 inquiry that will happen in the Office of the Maintenance Officer. We'll see you next week, same time, same place. Have a good week ahead.